want to thank our sponsor, Higgs Fletcher Mack, for organizing the CLE and sponsoring it. We have two great speakers today. Anna Ludke, she's a partner at Higgs Fletcher Mack. Her practice focuses on corporate entity matters and real estate transaction. She's an innovative and versatile attorney experienced in business planning, entity formation, maintenance, contract matters, and real estate transactions. She was selected as San Diego's Super Lawyers Rising Star in 2023 and 2024. And then we have Stephanie Pfaff. She's also a partner at Higgs Fletcher Mack. She has over a decade of experience working in various tax and real estate related transactions. Her practice primarily focuses on transactional tax planning, real estate tax matters, including all aspects of California documentary transfer tax, property tax, qualified property zones, like-kind exchanges, and renewable energy tax credits. In addition, Stephanie's practice also includes advising tax-exempt and non-exempt nonprofit organization and closely held businesses. She also advises clients in transactional tax and real estate matters for estate planning, trust, and family-owned businesses. So this webinar today will focus on common assignment and subletting traps and commercial leases from a tenant's perspective, and also offer some practical strategies to address them. While landlords seek control over who occupies their property, tenants need flexibility to adapt and change their business models. And being in-house counsel, we all know that poorly drafted assignments and contracts create a lot of hidden liabilities. So we'll have an opportunity to kind of get in-depth information from our speakers on how to avoid those pitfalls. Anna and Stephanie, I'll turn it over to you.
Hi, great. Thank you so much. And thank you everyone for joining us today. I'm Anna Ludke, and that was a great introduction of me and what I do. But I will just summarize and say I assist businesses in their formation and governance, and of course with all real estate transactions, including purchases and sales and commercial leasing. I represent both landlords and tenants across all asset classes, including retail, office, and industrial.
Okay, my name is Stephanie Pfaff, and thank you for that introduction as well. I am a real estate tax partner here at Higgs. In addition to my transactional tax and real estate practice, I provide tax support for my real estate and corporate colleagues like Anna. So it's an honor to join her today to discuss potential tax traps that tenants may face in commercial leases of California real property. Okay, I will kick us off. So if we could move the slide up, please. Thank you. Okay, so today we're going to cover several topics. First, Anna will discuss the basics of assignments and subleases and why these tenant tools matter. We will then jump into the heart of our presentation and discuss potential traps for tenants. Anna will begin with discussing common potential traps in the primary lease, focusing a lot on the provisions of the lease, and I will follow up with potential tax traps arising from landlord actions outside of the primary lease. We'll then close our presentation with key takeaways and open the floor for questions if time permits. Okay, take it away, Anna.
Awesome. Thanks so much, Stephanie. Assignments and subleases, the basics. So we know that not all attorneys live in the leasing world, so I'm going to set the foundation for you. An assignment is a transfer of the entire leasehold to a new tenant. The parties involved are the original landlord, the original tenant, and the new tenant, sometimes called the assignee. The document that is used to utilize this transfer is an assignment of lease. In an assignment, the new tenant or transferee steps into the shoes of the original tenant, whereas a sublease is a partial transfer, such as the transfer of a portion of the premises or transfer of the entire premises for less than the original term of the original lease. The parties are the original landlord, the original tenant, who is now a sub-landlord, and then the new tenant, who is the subtenant. In a subletting situation, you are governed by both the original or primary lease and the sublease document. The key similarity is that landlord consent is often required for both of these situations, but a key difference is that there's privity of contract and continuing liability differences. So you might be thinking, why does this matter? Oftentimes tenants take a lease that they're given from a landlord and view a lot of the provisions as boilerplate. Assignment and subletting provisions are often one such provision that is overlooked by a tenant. You care about the rent, right? How much are you going to be paying in rent? How long is the term? And then do you have any options to extend the term? And again, at what rent? I'm here to share that it is important to look past the boilerplate and really focus on what is written in the lease. Sometimes assignment and subletting clauses can take up one or more pages of the lease. And as you can see from this slide, there are differing goals between a landlord and a tenant. A landlord wants to do its best to maintain control over the project and its tenant mix, whereas a tenant wants to maintain flexibility and preserve its lease value. For tenants, assignments and subleases are tools that can be used to manage change, whether or not they are downsizing, expanding elsewhere, or going through a corporate transaction. Okay, so let's go ahead and jump into common potential traps in the primary lease. So we can't cover everything today. We only have the 1 hour together to discuss assignment and subletting clauses. So I'm focusing my discussion on these 5 most common, very common traps. So like I said earlier, oftentimes these will be boilerplate, quote unquote, boilerplate provisions in a lease, but I can assure you they are anything but. The savvy tenant wants to make sure that it is negotiating each of these points, or at least looking for them so that they're aware, so they can avoid hidden surprises down the line, and often very expensive hidden surprises. We're going to discuss a consent standard for an assignment and subletting, continuing liability, as I discussed earlier, bonus rent or profit sharing, a landlord's right to recapture the premises, and then a landlord's fees and costs that it may incur in considering a request for an assignment or transfer. But first, I wanted to share a very simple, very simple assignment and subletting clause. So, you'll often see this in your lease. Tenant shall not voluntarily or by operation of law assign, transfer, mortgage, sublet, license, or otherwise encumber, collectively a transfer, all or any part of a tenant's interest in this lease or in the premises without landlord's prior written consent. Again, very basic. We're focusing on the consent standard. So a landlord can either approve or deny the request at its sole discretion or at its reasonable discretion. And you see here the 2 different ways that that is written. Landlords often would like to reserve their consent to an assignment or a transfer in their sole discretion, whereas we recommend that tenants push for reasonableness. What does this mean? Well, here's some solutions for you. A tenant can request a time frame for a landlord's response. So earlier in that provision, if a tenant submits a request for an assignment or transfer, we could put a time frame that landlord must respond or provide a response within 10 days of receipt of tenant's request for an assignment or a transfer. A savvy tenant might also push for deemed consent, such that if landlord does not respond within such 10-day time period, that request for the assignment or sublease will be deemed approved. A tenant could also limit landlord's ability to deny the tenant's transfer request. So we often get into this when it deals with a permitted transfer or a permitted transferee. So landlord may deny the request except to a permitted transferee or other reasons, such as oftentimes tenants I see when I advise my tenant clients to bake in reasons why landlord might not approve the request. Like it would create a vacancy elsewhere in the building, it wouldn't mix with the tenant mix, or maybe there is an exclusive. You're in a retail shopping center and there's a Starbucks, but a Coffee Bean and Tea Leaf wants to come in. Those would be competing tenants, and landlords are not likely to approve such requests. So I did discuss the permitted transferee, and I know I apologize. I'm sorry, this is a long language, but this is oftentimes used, and I'll reference permitted transfers and permitted transferees later in my discussion, but I think it's important to show you this provision, and it's not always included at the outset. So having a good tenant's attorney to assist you and with giving language like this to insert in your lease is important. So if you know that when entering into a lease initially, if you know that you may sell your business, you may merge with another company down the line, or again, to maintain flexibility because you don't know what's going to happen, you may want to insert this clause into your lease such that the tenant will not be required to get landlord's prior written consent for any assignment or sublease to a permitted transferee. Another hidden trap or situation that really sometimes surprises people is the deemed assignment due to change of control. Many landlords draft their change of control provisions broadly so that normal business activity can inadvertently trigger a default. Tenants should try to limit these provisions to true third-party changes of control and carve out corporate events that don't change who is operating the business day to day. So as you see here, if the tenant is a corporation and they sell some percentage of their stock or otherwise so that the name on the lease doesn't change, but who is controlling the entity or the named tenant on the lease, if that changes, often it'll be deemed an assignment due to such change of control. Next, we're going to discuss the continuing liability of the original tenant. So oftentimes, you'll see this clause somewhere in the assignment and subletting provision. Regardless of landlord's consent, no transfer shall release tenant of tenant's obligations hereunder or alter the primary liability of tenant hereunder. So this might surprise some people if they're not aware, not really thinking, paying attention about it. But that original tenant, let me back up. So there's differences here, like I mentioned earlier, about the continuing liability of the original tenant in a sublease and an assignment. They're two different things. So in a sublease, due to the privity, the original tenant will remain liable to the landlord, because when you enter into that sublease is only between the original tenant and the transferee. The original tenant as sub-landlord and the transferee as subtenant, so that the primary landlord does not have any connection with the subtenant. So therefore, it's a step process. So that original tenant remains liable to the landlord for everything under the lease. In an assignment, however, depending upon the language, the original tenant could remain liable, or if you are able to negotiate, they would not be. So again, maybe you assign your lease to somebody, and then 3 years later, you get served a notice from the landlord that the assignee under that assignment, the new tenant, has stopped paying rent. There's some environmental contamination. There's some other default that is happening, or they've damaged the premises. Well, now your company is on the hook to that landlord because you agreed to continue to be liable for the lease obligations. And that, of course, undermines the whole point of an assignment. You sold your business, you want to move on, there's someone else there. But no, now you're still on the hook. Solutions for tenants include negotiating releases or burn-off provisions and limiting liability to the rent obligations, not all lease covenants. So this is important too, as like I mentioned, a release. You can negotiate a release upon the assignment to a credit-worthy assignee. If the assignee has the same or more financial net worth as you, then the landlord could release you for anything occurring after the date of assignment. And again, like I mentioned, like it says here too, limiting your liability to just the rent obligations would help in the event that the new tenant does some environmental contamination or damages the premises. You would not be responsible only if that tenant, if you only are limited to the rent obligations, you'd only be liable if the tenant stops paying rent. As you can imagine, landlords would love a piece of any upside. This is a sample provision that I see quite often in leases. It's called bonus rent or profit sharing. So this is kind of an interesting topic. Tenants want to preserve their lease value and monetize the lease if they can. What that means is if you have a below market rent and you maybe have a long term, there's value there. You could assign your lease to someone else and charge more in rent. For simplicity's sake, I'll say, let's imagine that you have a lease where the rent is $10,000 a month. And you're consolidating locations with your other entities. So you're consolidating the premises and you don't need this location anymore. So what you want to do is assign the lease and, oh, you found a tenant. You hired a broker and you found a tenant and they're willing to come in. And instead of paying $10,000 a month, they are now willing to pay $25,000 a month. Good for you. So that delta of $15,000, that would be considered bonus rent or profit rent. And the landlord is trying to get a piece of that and recapture that with a provision such as this. So you can see here too, if let's say also, for example, that it's not limited to just rent, there's key money, bonus money, or anything else paid by the transferee, the new tenant, to the original tenant, then that the landlord wants to recognize that as well. And you see at the end, the last sentence says, tenant shall give landlord a detailed statement of all consideration tenant either has or will derive from such transfer and the calculation of the amounts due landlord under this paragraph. Landlords often ask for a lot of documents when it comes to analyzing and considering a tenant's request, financial statements, information and details on the business, what it's done, etc. And this is just one more piece of the pie that they're wanting to know. If you're selling, say you're selling your business, so you have a business purchase agreement and you're trying to assign the lease, they want to look at all of that and see what is that buyer paying you in connection with the purchase of the business and in the assignment of the lease. So without protections built in or modifying that language on bonus rent and or transfer of profit, tenants may lose out on the benefit of their bargain. And then they may also, the biggest risk is they may also owe profit sharing or bonus rent on amounts that aren't true profit. So some strategies for tenants are to lower the percentage. And I often see that work on a tenant's behalf. A tenant can negotiate with a landlord that they would like to, instead of share 100%, they can share 50%. Or maybe it's 100% for 1 year of the remaining term, and then 50% for every year after that. Carving out that transfer to a permitted transferee. So if you're consolidating with someone else and they're going to pay more rent as part of the consideration, or they pay a certain amount for the lease, the value of the lease, then that would be excluded and landlord would not be able to share in that. Here's a good one, I think, that is often overlooked, but adding language in that deducts any brokerage commission, TI spent, concessions, free rent, and legal fees is huge for that tenant. And what this means is you hired the broker, who found a tenant for you that now you're going to be receiving $25,000 a month. So, and let's say the broker's fee was $40,000. So you would be able to recoup 100% of the money until your costs are recovered. Or you're a restaurant tenant and you spent $500,000 over what the landlord gave you for TIs. You would like the ability to recover that $500,000 from the bonus rent prior to sharing it with the landlord. And this is also huge and something I recently negotiated and put into a lease. I was adamant because I was said you might sell your business, and the way that this provision was drafted was that any money received from the sale of the business or goodwill could be deemed to be bonus rent or profit sharing. So I was successful in getting that in because the client didn't understand so much. She said, well, what does that matter? Well, if you get profit from the sale of your business, your landlord should not be able to participate in that. Here's another one that's sometimes surprising for people. Recapture rights refers to a landlord's ability to terminate the lease and recapture the premises if the tenant requests an assignment or a sublease. While that may sound harmless, it can destroy your flexibility or your thoughts of selling your business. Again, like I said, a lot of the times when a company or an entity person sells their business, one of the biggest assets that they have is that lease itself. So I'm selling my business, but I'm in a great location with high foot traffic, or we have lots of space, great TIs, low rent. If a tenant tells the landlord or asks the landlord, submits a request for an assignment or a sublease, if there is a recapture provision, then the landlord could say, oh, you want to assign, you want to sublease, you're terminated. Your lease is terminated. I get the space back, and then you can move on your merry way. This might be helpful for a landlord, and you can understand why a landlord would want this if they want to relet the space, or maybe they've been talking to a larger tenant or a tenant who needs more space, and they can assemble your premises and a couple other in a vacant project or in an office building, for example, and offer that to the new tenant. I also wanted to say, watch out for these clauses, as they're not always called recapture. It's a pretty big red flag to watch out for. So sometimes they're called landlord's option as to subject space, or landlord's option as to the premises. Something else that seems harmless. A good strategy for tenants is to ask to strike this altogether. Say, no way, we agreed to this term and this rent, so you don't get to recapture my premises. That works sometimes. Other times, you can add in carve outs for your permitted transfers. So that's a really good one to say, except for transfers to permitted transferees, and then, enter that language. And insert a time frame for a landlord. Again, I think it's always helpful for when you need to ask a landlord for anything to insert a time frame where you're going to require landlord's response within that time frame. And then if they don't respond, they fail to respond, then it'll be deemed approved, any request. And then last but not least, strategy is to include the right to rescind the transfer request. So let's say you send landlord written notice, written request asking to assign your lease. Landlord responds within its 10-day or 30-day timeline, whatever it has, and says, I'm going to recapture this space. Well, then if you have this right to rescind language, then you can say, oh no, okay, I wasn't, I don't want you to terminate my lease. I'll keep it, or I will figure out something else. So there's a couple different things you can do. The right to rescind may not help a tenant who needs to get out due to expense. Well, it may, if the landlord's rescinding the lease, it may help the tenant who is having financial difficulties and needs to get out of the lease. Okay. Okay. And then another potential hidden trap, which is often not discussed as much as it should be, are fees and costs. Landlords often shift their costs to tenants, and sometimes without limit. So you can see here, this is a common phrase. I pulled it from one of my own leases. Tenant shall pay all of landlord's costs incurred in reviewing and processing a request for assignment or sublease. Landlord's costs shall include all legal reviews and expenses and all direct and indirect expenses incurred by landlord arising from any assignee or sublessee taking occupancy in the building or the project, including the cost of all additional security, janitorial, cleaning, and trash removal services. So that is a very landlord-friendly provision. We were not leaving out anything. So sometimes I know in some leases there may be just limited to landlord's attorney's fees or administrative review fees or processing fees. And there's sometimes, as you can see, a strategy, a cap on fees. a savvy tenant will negotiate for a cap on fees. And you might say, and it may not even discuss the payment of landlord's costs and expenses. It could just be in order to review and consider an assignment or sublease request, tenant will deliver all documents to landlord, provide the draft assignment of lease document, and pay a fee of $500, $1,500, $5,000 to landlord for landlord's review and consideration. So I have to share a recent sublease I was involved in with a client where we had to review the original lease, the first sublease, and then draft the second sublease. And there was a lot of back and forth. Landlord consent was required, and then there was a guarantor situation going on where we wanted to change guarantors, and the landlord was able to collect all of its legal fees in that, and they were over $6,000. So sometimes the request for an assignment or a sublease can make transfers uneconomical for tenants if they're not anticipating the legal fees and costs. So the good strategy for tenants is try to negotiate a cap on any such fees or require reasonable fees only. I probably think that the landlord in that situation thought that that $6,000 fee was reasonable, but the tenants may not always think $6,000 is reasonable to review and or process a assignment or sublease request. Okay, so I apologize if I spoke very fast. I know I covered a lot of material. I'm happy to go back and elaborate on anything at the end of the presentation, but now I'd like to transfer over to Stephanie.
Gotta turn off the mute button. All right, thanks, Anna. That was excellent. Okay, so I'm now going to move us into a potential tax trap discussion. And let's see, so if you could advance the slide, please. Anna. Oh, thank you. Okay, so while this presentation so far has been focused on tenant's assignment of the lease, there are surprising traps that can come up when the landlord's done something like assign its interest in the property, or if it undergoes a change of control. And that's a different kind of change of control than what Anna had raised earlier, but we'll dig into this now. All of this is surrounding Prop 13. I assume many of you have heard of Prop 13, but if not, and to provide a refresher to those who have, I'll just begin with a short overview. So Prop 13 was enacted in 1978, and it forms the basis for the current property tax regime in California. Under Prop 13, the general property tax rate throughout the state is limited to 1% of the property's assessed value. However, due to direct levies and special assessments in some areas, the overall tax rate could be slightly higher. I think around 1.2 when I think of a number in my head. And Prop 13 is unique to California. What it does is establish a base year value concept for property tax assessment. And in general, this original base year value is the fair market value of the property when acquired, so typically the purchase price. And once that original base year value has been established, the value increases to no more than 2% per year, and this is known as the adjusted base year value. The adjusted base year value remains in place as long as the property remains in the same ownership, but when there is a sale or other change in ownership event, there is going to be a reassessment. So I'll use an example so you can see how this works. If you bought your house for $100,000 in 1980, your original base year value would be $100,000, and that amount would increase annually no more than 2%, and you're paying the 1.2% property taxes on that value. You sell your house today for $1 million, the property will be reassessed to its fair market value, again, presumably the purchase price, and your new buyer would have an original base year value of $1 million, and then that would increase annually no more than 2%. So from this example, you can see how Prop 13 protects property tax value, especially for property that's been held for a long time. And that's kind of what sets the trap here for tenants. Now, I just want to premise here that my presentation is not a deep dive discussion into Prop 13. So I'm not going to talk about new construction, long-term leases, even though you would think it would come up in this topic. I'm going to avoid that. There's a lot of complexities there and a lot of complexities in Prop 13 in general. So that would be a great separate discussion, but for today, I'm just going to hit on two areas that are change in ownership that create a trap for tenants in their commercial leases. The first is a landlord selling its property or conveying its property by grant deed to a third party. And the second is if the landlord's a legal entity, it undergoing a change of control. And again, this is different than the control that Anna mentioned earlier, and I'll explain that when we get there. Okay, let's move ahead. Thank you. Okay, so on this slide, I've included an excerpt from Property Tax Rule 462-100, and this is the rule that addresses change in ownership events involving leases. Because we're not going to do a deep dive into Prop 13, I'm just going to focus on the language that's underlined. And what this says is the following transfers result in a change in ownership. So as to lessor's interest, the transfer of lessor's interest in taxable real property subject to a lease with a remaining term of less than 35 years. And this is where I see most of our leases falling. They're less than 35 years. Maybe they're a 20-year lease, well, let's say a 10-year lease with 3 5-year renewal options. The rule means here that you need to count those written renewal options. So that 10-year lease with the renewal options is actually a 25-year lease. Still keeps it under 35. And so this rule that's highlighted here will apply if landlord makes any transfer of its property. Okay, I have an illustration on the next slide of how this looks. Okay, in our first hypo, landlord he's decided he's going to sell his property to a third-party buyer. The property is subject to a triple net lease with 20 years remaining. The landlord, to effect the sale, is going to execute a grant deed and assign the lease to the new landlord. Now, as I mentioned earlier, a conveyance by grant deed to a third party is a change in ownership event. So this means that the property will be reassessed to its fair market value, which will establish the new base year value on which the new landlord or tenant, depending upon the lease, will pay the property taxes. And here we're assuming it's a triple net lease, so tenant's on the hook. So if we use an example of the property having a prior base year value of $1 million, and we'll just use a simple 1% property tax rate, tenant would be responsible prior to the sale for paying annual property tax of around $10,000. That $1 million, of course, is subject to the 2% increase. I'm not going to complicate the math. I'm going to keep it simple, hopefully. When that property sells, if we assume it's a $5 million purchase price, and that's the new base year value for the new landlord, the property taxes are going to increase to $50,000 per year. So that's a pretty significant increase. And for a tenant with a triple net lease, they're on the hook, and it's not a one-time expense. It's important to note this is a year after year expense, and that can be a significant problem for some tenants. So if this tenant had 10 years remaining on its lease when this took place, and you quantify that increase every year over the 10 years, that's $400,000. So this can be a problem for a tenant that is not expecting this. In my practice, I see it more often where this situation arises when there's been a death of the landlord. And so let's move to the next slide and I'll show you how that works. Okay, so under this hypo, we have the property owned by a landlord who's an individual. That individual dies, and their interest in the property passes to their beneficiary. Here, let's assume it's a child. There's no parent-child exclusion available for commercial property, so the property is going to be reassessed as of the value on the date of death. So if we assume this is a family-owned property, it's been in the family for a long time, that original base year value is nice and low. Your tenant's paying its taxes on that low value. Death has triggered the reassessment. Now it's going to be brought up to fair market value, and it's going to be a problem for some tenants. They may not be able to absorb this. So this is just an example of a trap. We'll talk about it more in the coming slides, but I want to move into the next change in ownership event that can arise with landlords. So Prop 13 has a change in ownership event known as a change in control. And on this slide, I have an excerpt from California Revenue and Taxation Code Section 64. I'm not going to read it to you. I don't want to lose you. So I'm just going to focus on the takeaway. the takeaway here is that if someone new acquires more than 50% of the voting stock of a landlord that's a corporation, or more than 50% of the capital and profits of a landlord that's a partnership or an LLC, a change in control occurs. All California real property held by that landlord, it could be more than just this particular property, undergoes a change in ownership and the base year value is increased to the fair market value. So on the next slide, again, I have an illustration for you. Okay, in this hypo, landlord's going to bring in a new partner. Maybe they've got some improvements planned, and that new partner is going to take a 51% interest in the landlord entity. So following the rule we just went over, someone new, party B, has acquired more than 50% of the capital and profits of the landlord LLC. As a result, we have a change in control. This is a change in ownership event. Property is going to be reassessed to its current fair market value. We assume that's going to be a higher value than what it was previously. All of those increases are going to pass through to the tenant. A common question that comes up, and I'll just, address it here. A lot of times people wonder why the entire property has been reassessed. Why not just 51%, since that's what the new investor got? It's not, the rule doesn't work that way. This is an all-in. So if there's a change of control, the entire property is reassessed. Now, since we're doing a comparison to a commercial transaction to a natural transaction, on the next slide, we'll talk about what happens when there's a death in a landlord entity, well, the owner of a landlord. So here, we'll assume that landlord LLC is owned 100% by individual A. Individual A dies and his child, individual C, receives his 100% membership interest in the landlord LLC. There's no parent-child exclusion available for the situation. So what we have is individual C acquiring control of landlord LLC because it's more than 50%, it's 100%. So as a result, change of control, change in ownership of the property, it's reassessed, brought up to its fair market value. I want to just stop here and explain how this is reported. So in the first two hypos, we have a grant deed that's recorded. You have an assignment of a lease so that the tenant's aware of what's happening. The tenant may not know this is happening. Presumably they might know about a new investor coming in, but they may not know right away that there's a change of control. And they may not appreciate that when individual A here died and individual C stepped in, that is a reassessment. And so when it's reported at the state level. So it goes to the California State Board of Equalization, who then notifies the county, and the county is then eventually reassessed. It can take some time before this happens. And so the tenant, if they're receiving the bills or if the bills are passed on to them, it could be a significant increase plus supplemental tax bills to catch up that time period. So it's a fairly big trap that a tenant could find itself in. And it, just thinking about how it could be even greater of a shock if the tenant has a longer lease term left, that year after year, I guess the quantified exposure is greater. And then if that increase is greater, that's just going to be the increase to them every year. So it makes tenants pretty upset. I've seen it a few times, and they're wondering how could this possibly have happened. So on the next slide, we'll look at how it happened and what they could have done and what they should do going forward. So on this slide, I've taken an excerpt from Practical Law just to illustrate the trap we went over. So in this language, tenant is responsible for its proportionate share of all real estate taxes. And within the definition of real estate taxes, the parties have expressly agreed that those taxes include any increases attributable to a change in ownership under Prop 13. Now, in the previous slides, under the 4 hypos, where the change in ownership events took place, there were increases, this provision says that tenants are responsible. So if a tenant didn't realize this trap or didn't realize or appreciate the risk at the time they signed the lease, this is going to be a big surprise. So to avoid this trap, savvy tenants try to negotiate in protections into the provisions of the primary lease. So on the next slide, we have an example of that. Okay. Again, this is another excerpt from Practical Law, just to illustrate a potential protection for tenants. So under this language, the tenant is going to build into the primary lease an exclusion from the definition of real estate taxes that expressly provides that such taxes shall not include increases attributable to change in ownership under Prop 13. As written, this is a blanket exclusion. It is not likely to be agreeable by most. They don't want to give you a blanket. And if they do give you a blanket, they may include the bracketed language, which is in green, which means that this blanket exclusion is personal to this particular tenant. It is not assignable in any assignment. So this is not likely to be the approved form of Prop 13 protection, but it's a good, extreme. What you're probably going to see more likely is a landlord agreeing to a Prop 13 protection, but limiting it to landlord caused events. So in our 4 hypos, landlord sold, landlord died. These are areas where the tenant can carve out. But if tenant's responsible for the change in ownership, increase in the property taxes due to the length of the lease, which we didn't cover today, they would be on the hook for that. There's a lot of times discussion about new construction. That gets built in, that picks up TI work, that picks up any new additions to the other parts of the building tenant may not be renting. So another way to do it is to put a cap on tenants' exposure. So I guess my point is there's a lot of ways to protect yourself, but the biggest takeaway is that tenants need to be aware that Prop 13 is out there. And if they're not looking at the terms of their tax provisions, they could be responsible for any increase, even if they had nothing to do with it. And so one thing I do like to point out is if you can't get Prop 13 protection, if the landlord's absolutely against it, could the tenant then consider asking for protective language in the lease that would allow it to participate in any dispute with the county? So when the county comes with their reassessment, there's an opportunity to appeal. Well, as the owner of the property, they hold the right to appeal. If the tenant doesn't participate, there's really no incentive for the landlord to pursue an appeal. But if the tenant has the right to participate, it could appeal the value. It could also dispute whether or not a change in ownership existed at all. It could have been an exclusion that wasn't captured. So there's a good way for a tenant to get involved. It doesn't have to be Prop 13 protection language, although that's preferred. But having the right to participate is another way they can protect themselves. Okay, we're on my last slide. So I just wanted to close out the tax discussion with tips and reminders for tenants. So first, change in ownership events can occur in a variety of ways, and they can significantly affect an unsuspecting tenant responsible for all property taxes under their lease. Next, it's best to address the Prop 13 protection during the LOI phase. It's harder to get that in when you're already drafting, get it in at the LOI. Be sure to keep an eye out for any tax provisions that do not address Prop 13 and are overly broad. These are filled with traps. Even though they don't say Prop 13, there's probably language in there that covers it. You just want to be careful. And be sure to work with tax counsel who can review the boilerplate tax provisions carefully and negotiate protections for the tenant. Again, if you can't get the protection in that we discussed, try at least to get the right to participate, but the protection plus participation, that would be best. And, oh yes, so today we focused really on the primary lease, but as you can see, the next step in that, it would be a tenant assignment and sublease agreements. There are tax traps there as well, and we do not cover those. But if a tenant has some Prop 13 protection in the primary lease and it's assignable to a new tenant, it adds some value there, so there's a double bonus. And with that, I will hand it back to Anna. Thank you.
Thank you, Stephanie. It's always surprising for tenants when the standard language in the lease tax increases are passed on to them. So from something that they didn't, like you said, affect. So a landlord effect. So just one more of the potential traps. So we're nearing the end of our presentation, but we wanted to leave you with a couple key takeaways. So as we've reiterated several times, negotiating the assignment and sublease provisions in the original primary lease is critical to maintain flexibility for our tenants. Don't rely on the boilerplate language. Know that there are a lot of things that you can do to negotiate or push back on the landlord. You may not win them all, but you may win a couple. or you may win half. So, and it's really important when you're pushing back to prioritize what is important to your business, what is important to your business goals, your business strategy, and how to maintain that flexibility for the future. Because proactive drafting prevents liability, preserves lease value, preserves flexibility, and can help prevent surprises such as the ones we discussed about transferring or property taxes, transfers, canceling the lease, terminating the lease due to those recapture rights. Attorneys can help tenants negotiate practical balance solutions. So that's where we come in. You're a tenant's attorney. We've seen a lot of leases from a lot of different landlords. Some are national institutional landlords with properties all over this country. Some are your local landlords that maybe own 1 or 2 properties. There's a range of different possibilities in different forms. So we have our own, and we also are happy to work with any kind of landlord form out there. And then lastly, without limiting the broad reach of boilerplate provisions in a lease, a tenant can be exposed to unforeseen costs. Those legal and administrative fees, those increases due to property taxes, we didn't talk about it, but there's increases due to insurance costs of a landlord. There's just a lot to look out for. So with that, we have left a good amount of time for some questions.
There are actually 2 questions in the chat. Jenny's first question was, when using the California Realtor Association template, if the tenant goes through 100% stock sales, will it trigger assignment clause? Tenant might argue the legal entity is the same.
I'd have to see that clause. So, Jenny, I would suggest if you want to discuss that, maybe you can email us after the presentation. I'm not as familiar with the California Association of Realtors template as I am with the AIR CRE template. I know that in that one, I know that in the AIR form, if the tenant undergoes 100% stock sale, yes, the assignment and subletting clause is triggered in the AIR form. So I'd have to see the language in the CAR form to confirm.
Anthony has a question. If A's property is held in a trust, after A dies and C steps in as a trustee, is there no Prop 13 issue?
That's a good question. So trusts are complicated. Like I said, I wish I could have gone into more detail on all that Prop 13 holds, but when you have a trust owning property directly or a legal entity, you look through the trust to the beneficiary. And so if A was the beneficiary of that trust and dies, there's a change in ownership because a new beneficiary steps in. And so no, it's not a way to get around Prop 13.
And Karen wanted you guys to go over the use of an estoppel certificate as leverage for building repairs.
Okay, I can address that one. So while not directly on point with assignment and subletting, anytime, let's say the landlord wants to sell the building, sell the project, or obtain financing on a project, they're going to ask a tenant for a tenant estoppel certificate. So in this certificate, it'll have various terms, which the third party, i.e. the buyer of the building or the lender, is going to request the tenant to make certain statements. And then if all goes well, the tenant will be stopped from saying something to the contrary of what it states in the tenant estoppel certificate. So for example, you can have your own custom form. We have our own custom estoppels, and then often also use the AIR CRE form of estoppel. It's very good. In it, the tenant confirms that the date it took possession or the commencement date and the expiration date of the lease. Well, yes, that third party can review and analyze the original lease itself. It also wants the tenant to confirm, yes, the lease commenced here, and yes, I know the expiration date. You can also say in there whether or not the tenant is in bankruptcy, or if the tenant knows of any default either on its part or the landlord's part. But Karen's question goes to, how can one use an estoppel certificate as leverage for building repairs, etc.? Oftentimes in an estoppel certificate, the party seeking information will say, do you know of any uncured defaults or any damage, anything relevant to your lease of the premises and or the common areas of the building or the project. So I'm assuming, Karen, that you want to know how the landlord or can use an estoppel certificate as leverage, or is it the opposite? So if a tenant writes none, which they often do, they often get these and then they need them back because there's a provision in the lease that says that the tenant is agrees to return the estoppel certificate within 5, 10 days, whatever, business days of its receipt. So they fill them out and they submit them back. So if you're a landlord and you want to, the tenant writes none, there's no repairs or there's nothing wrong with my space or nothing wrong with my premises, then the landlord or the lender or the buyer can take that estoppel certificate and say, look, tenant, you said that there was nothing wrong. You don't know of anything. You don't know you had no complaints here. What has changed? So in that sense, however, I will caveat that and say things happen all the time. Maybe in between, maybe a month or two has gone by since the tenant filled out that estoppel form and something has happened. There has been damage that requires building repairs. In that instance, that estoppel certificate may not be any good with regard to any damage or building repairs. Did that answer your question?
There are no more questions in the chat, but if anybody else has any questions, please unmute yourself and ask our panelists. We have a few more minutes.
Yeah.
Time.
Okay. Well, we are happy to answer any questions you may have down the line as well. So here's our. Oh, go ahead.
Oh, I'm sorry. I was struggling to get off of the mute. Thanks very much for this. This was really informative and great to see from a tenant perspective. And I hadn't seen that level of detail on Prop 13, so very, very useful. And a new thing to negotiate that I hadn't really thought much about. So thank you.
Glad it was helpful.
That maybe Prop 13 is a CLE that they can present in more in depth if that's something of interest to our attendees.
Well, the traps of subleasing, I think, in general, because it seems that there are more subleases than leases. All the properties that I work with, I'm dealing as either a sublessor or sublessee. So this is something that is a problem in either circumstance. Really helpful. Also, how it, it's a little bit separate, but interplay with insurance and how your provisions can help or hurt your potential insurance claims would also be useful.
Okay. Yeah.
But no, this is great. Thanks again.
Okay. Well, yeah, we really wanted to focus on the original primary lease because oftentimes, a tenant may be surprised when it comes down to the time to assign or sublease what their lease what this particular section of their lease says. It could be very landlord friendly, and it's a good way, understandably, for a landlord to want to have control over their building, their tenant, their costs, insurance, property taxes, etc. So we're happy to present a topic that was helpful.
All right. Well, I want Anna and Stephanie, I just want to take the time to thank you both for doing the presentation and thank Higgs Fletcher for being a sponsor for ACC San Diego and all the attendees for coming to the CLE. You guys have Anna and Stephanie's information if you have further questions or need their services with respect to your leases, subleases, anything of that sort. I think we put in the chat that the presentation will be available on the website, and the CLE certificate will be sent to the email. So thank you for your time. I'm sure we'll see you guys all soon at another event.
Thank you.
Thank you all.